Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're talking about the recent ruling of the Quebec Superior Court on Bill 21. Passed by the National Assembly of Quebec in 2019, Bill 21 prohibits public servants from wearing religious clothing or symbols while on the job, ostensibly in an effort to preserve the religious neutrality of the state. The bill was justified on the grounds of a French concept called laïcité. Laïcité is a notion of more than just separation of church and state and freedom of religion. It creates freedom from religion based on the concept of a totally neutral state. The law applies to public employees like teachers, crown prosecutors, judges, police officers, and it prohibits them from wearing all religious symbols regardless of the size of the object. So it prohibits the wearing of a hijab, a kippah, or a cross. In order to avoid a legal challenge on the basis of the Canadian Charter, Quebec invoked the notwithstanding clause, but the law was still challenged as a violation of religious freedom. Here to discuss the outcome of that case is Chris Kissinger, incoming executive director of the Running Mate Society, and will then be joined by our panel of legal experts to talk about what this case means for freedom of religion in Canada. Chris, thank you so much for joining me today. Now, can you tell our viewers what the outcome was in this case?
Absolutely, Christine. So effectively, what the Superior Court ruled was that despite the flaws of Bill 21, and the decision, which is over 1,000 paragraphs, went into quite a bit of detail on how Bill 21 effectively prevents certain religious adherents from participating fully in Quebec society. The court ruled that because of the invocation of Section 33, the notwithstanding clause, it was not in a position to strike down the legislation. There were a few exceptions regarding aspects to which Section 33 does not apply, but on the whole, the law has survived this initial constitutional challenge.
And those exceptions relate to English language schools, is that correct? So teachers, for example, in an English language school.
That and the provincial legislature, correct.
Okay, interesting. Now, can you explain on what grounds the law was challenged if Section 33, the notwithstanding clause, had been invoked? This clause allows legislatures to pass laws that derogate from charter-protected rights if they invoke this law and they allow them to derogate for a set period of time. So can you explain what the sides argued in order to get around that notwithstanding clause?
Yeah, absolutely. There were numerous arguments that were made. I think it's fair to say that most of them were novel, but in my view, that doesn't make them any less valid or persuasive. One of the arguments was that the law violated section, I believe it's 28 of the Constitution, which guarantees the protections of the Charter equally to men and women. One of the other arguments that was made was with regard to Canada's constitutional architecture and the role of unwritten principles within the constitutional architecture. So effectively, what the argument there was that the notwithstanding clause, while it may apply to the enforcement of the guarantees of the Charter, it does not apply to pre-existing guarantees or to underlying constitutional principles. And the argument there was that there is this pre-existing prototypical form of religious freedom that predates the enactment of the Charter. And so consequently, the notwithstanding clause cannot be used to override that underlying guarantee. But disappointingly for some of us, the court did not accept that conclusion.
That was interesting and certainly a novel argument. Now, in your view, if Section 33 had not been invoked in this case, would the law have been found to be a violation of religious freedom?
No question. There's no question that the law would have been struck down on the basis of Section 2A, religious freedom, and also Section 15, which guarantees equality on the basis of religion. And the reason for that, Christine, in my view, is that this is not just about religious freedom or religious equality. It goes to the underlying principle that animates both of those guarantees, and that's the religious neutrality of the state. And now, what's interesting is that the Quebec government has tried to justify this law on the basis, as you said, of laïcité and this distinct understanding of religious neutrality. But as I've written and as I've argued elsewhere, the law is very inconsistent with how that principle, namely religious neutrality, has actually been understood in our case law. And I'm quite confident that were it not for the invocation of Section 33, the law would be found to restrict and violate that principle.
Well, it's certainly an interesting decision, and I'm sure there will be an appeal. Chris, thanks so much for joining us. We're going to go to commercial and be right back. Welcome back to Canadian Justice, where we're talking about the recent decision in Quebec upholding, for the most part, the government prohibition on religious symbols by public employees. I'm joined now by our panel of legal experts. David Rand from the Alliance for Secularism, Amira Al-Gawabi, a journalist and human rights advocate, and Derek Ross from the Christian Legal Fellowship. Thank you all so much for joining me today. Mr. Rand, I'd like to start with you. Can you give me your initial reaction to the decision by the Quebec Superior Court, which for the most part upheld this law?
Well, we like the fact that it upheld mostly the law, but it only did so because of the notwithstanding clause. And it made exemptions for English language schools and also for the wearing of face coverings in the National Assembly. Obviously, the judge is firmly opposed to secularism, and he made use of the loopholes in order to weaken as best he could Bill 21. The damage he could do to the bill was limited by the notwithstanding clause, and so we congratulate the Quebec government for having invoked it in order to prevent further damage.
Ms. Al-Gawabi, same question to you. What are your initial thoughts about this decision?
Well, thank you so much, Christine, for having me and for having this really important discussion. It's absolutely disappointing to see the sort of half measures that the judgment brings about. It clearly acknowledges that rights are being violated, and that is really important to emphasize here. What this law has done since its inception is create two-tier citizenship in the province of Quebec. Essentially, it means that people who express their religious freedom by wearing, for instance, a hijab like I'm wearing today, a kippah or a turban or any other religious symbol that they feel in a democratic society that they have the right to wear and exist as anyone else, that they are not able to hold certain positions, professional positions in society. This is fundamentally discriminatory. And while the withstanding clause has been used, and that's why it wasn't fully struck down, it is absolutely imperative that we see the appeal of this decision continue. And we have already heard that the two organizations, the National Council of Canadian Muslims and the Canadian Civil Liberties Organization, are going to appeal this decision because it really must be struck down as an egregious form of discrimination.
Mr. Ross, your reaction to this decision from the Quebec Superior Court?
Well, I would certainly agree with Ms. Al-Gawabi that this is a very disappointing outcome. And that is because the effect of the decision is the law has been upheld. And the result of that is that many Quebecers of faith cannot work in public sector jobs or for the government unless they are prepared to hide their religious identity. And that simply cannot stand in a free and democratic society, in my view. But at the same time, as disappointing as that outcome is, there are a number of very significant observations that the court made affirming the importance of religious freedom and religious equality. And one of the most striking was the court's observation that forcing someone to choose, as this bill does, between their soul or their conscience on the one hand, or their chosen profession on the other hand, is a cruel and dehumanizing choice. That's a very striking observation. And that and a number of other comments that the court made throughout the decision, I think will be very important as this case is appealed and undoubtedly makes its way to the Supreme Court of Canada.
May I respond?
Yeah, Mr. Rand, I was going to ask you about that specifically. How do you view this? Is there a choice that people are forced to make between their profession and their faith with this bill?
Political symbols are already banned by other legislation worn by civil servants in Quebec. And religious symbols should not have a privilege of being allowed any more than political symbols. In fact, the judge had to invoke the soul of religious believers in order to justify this privilege, which opponents of Bill 21 want to maintain, the privilege of engaging in religious advertising while on the job. Nobody is prevented from working in any job. All they have to do is remove the religious symbol while they're on the job in certain jobs in positions of authority in Quebec. A religious symbol is of no more value than a political symbol. We wouldn't allow somebody to wear a T-shirt that said, vote for Quebec independence or vote for the Conservative Party of Canada, and we shouldn't allow them to wear a religious symbol that promotes a particular religion either.
Now, it's a really fascinating debate. Ms. Al-Gawabi, I would love to get your response to that take as soon as we come back from these commercial messages. Thank you so much. Welcome back to Canadian Justice, where we're talking about the decision of the Quebec court to uphold a law that bans government employees from wearing religious symbols. Now, Ms. Al-Gawabi, I want you to respond to what Mr. Rand said in the last segment, where he's arguing that there isn't, public sector employees are not being forced to choose. They're just being asked not to wear between their faith and their job. They're just being asked to keep their practice of their faith, in the private sphere and home, not bring it to work with them. How do you respond to that argument?
Well, I think it would be helpful to sort of clarify what you actually just said about practice and what Mr. Rand said about symbol. This is a practice. This is a religious practice. It is part of my faith practice, for instance, to wear a headscarf. It is not something that I do only in the privacy of my own home. In fact, when I'm in my home, normally with my family, I don't wear the hijab. It is something that I do as an act of faith when I am out in public, not as a way to proselytize or try to spread my religion, but as my own personal relationship with my faith. And so really, it's very important when we talk about these issues to be accurate and not to be sensationalizing what is actually happening here. And just to sort of reinforce what my colleague, Mr. Ross, said in terms of the way that the judge was sort of looking at this argument, he actually wrote, and I'm actually going to quote from the judgment. He said, not only do these people feel ostracized and partially excluded from the Quebec public service, but in addition, some see their dreams become impossible, while others find themselves stuck in their positions with no possibility of advancement or mobility. Do we really want to live in a country in which some people, simply because of their own personal faith practices, which is guaranteed by our charter, they cannot pursue their dreams of serving the public and the greater good and being productive members of society? Is this the kind of society we want? I would assume that many of your viewers would say, absolutely not. There is nothing offensive about my headscarf, nor should there be about someone's kippah or a turban. We live in a country in which people are free, and I think that is a country we all cherish very much. And what's happening in Quebec is contrary to that.
Mr. Rand, yes, I just want to get Mr. Ross's take on this segment, and then I'll turn to you. Mr. Ross, your reaction to this debate about whether or not it's an undue violation and forcing people to choose between their faith and their work.
I completely agree with the court's assessment, and the court went out of its way to say that religious symbols aren't equivalent to political symbols, nor are they accessories that can simply be taken on and off. They are core to the very being, to the very soul of the person who wears them. And for someone who does not share that faith, understandably, that might seem a foreign concept and even irrational. But from the perspective of the believer, and that is what the Constitution says we have to take into account, this is core to their identity, and forcing them to remove that, to deny that, to disavow that is as core a violation to their integrity and dignity as one can imagine. And that's what the court recognized.
Mr. Rand, your reaction.
Well, the judge did indeed say that religious symbols are way more important than political symbols, and he's completely wrong. And he's showing his prejudice in favor of religion and in favor of religious privilege. There is no reason that religious symbols should be considered more worthy than political ones. He had to invoke the existence of the soul, a totally fictional, anti-scientific concept. He had to invoke the soul in order to justify his opinion that religious symbols are more important than political ones. They are not. A hijab is no more important than a T-shirt that says vote liberal or vote for some other party. It is no more worthy, and it can be removed. Nobody is being excluded. A person who wears the religious symbol at all times and refuses to take it off, even when they go to work, even in the civil service, even in a position of authority, then they're saying that their religion is more important than their job, and maybe they're not qualified for the job in that case.
Ms. Al-Gawabi, your response.
Well, Mr. Rands, absolutely has the right to espouse these views that he's sharing today. But what I can tell you is that the vast majority of Canadians are very proud of living in a democracy which has a charter of rights and freedoms, which includes the right to freely express ourselves, to freely practice our religion. And so this is something we need to appreciate, that we live in a country like this. And I would also like to point out that the Supreme Court of Canada itself has ruled on issues of religious freedom and has said that no one should be expected to park their religion.
Welcome back to Canadian Justice, where we're talking about religious freedom in Quebec. Now, Mr. Rand, I want to switch gears from our last conversation to turn to this notion the law is designed to protect, this idea of laïcité. Can you explain this concept to our viewers and why it's considered important in Quebec society?
Well, I'd like to correct one inaccuracy from your initial remarks. Laïcité doesn't go beyond separation of religion and state. It simply implements it more fully. And freedom from religion is also required as part of separation. So basically, whether you call it secularism or whether you call it laïcité, you need to have separation between religion and state for it to be complete. And that includes both freedom of religion and freedom from religion, both of which are part of freedom of conscience.
Now, Ms. Al-Gawabi, can you respond to the concerns of those people in Quebec society who embrace this notion of laïcité and want to create a secular civil space, preserving religious observance for private life?
I think it is understandable, given Quebec's history with the church and the negative implications that that historical relationship has had on Quebec society, which does indeed lead to a popular opinion being generally in support of Bill 21. But that being said, as more and more voices came to the fore to explain the very deteriorating sense of contributions and the ability for people to take part in society due to this law, we actually saw a slow shift in public opinion. So, in fact, while there may be initial support for a law like this, when people understand what is actually at stake, that their fellow Quebecers who, for instance, want to enter the teaching profession when they were missing teachers, they did not have enough teachers, that to really prevent people who are experienced, who are dedicated to become teachers, to prevent them from doing so simply because of their own personal religious expression, really was, a step too far.
You have statistics to back up your assertion?
Absolutely.
That support for Bill 21 has been reduced in Quebec. I'm not aware of that.
Thank you, sir. There have been indeed some gains in support for Bill 21. It's still a majority not supported. You're absolutely right. However, as more and more people are made aware of its implications, we have indeed seen a shift in that opinion. And so
I haven't seen it.
So fair, sir. So what I'm trying to get at is, I think what we need to do is continue to educate people about the value of having a diverse society in which all of our differences are celebrated and welcomed, versus trying to have the state go one step further, sure, separate religion from the state apparatus, but not to go into the wardrobes of the residents of that state to tell them what they can or cannot wear. That is a step too far, and certainly is not appropriate.
Mr. Ross, we have about 30 seconds. Mr. Ross, just your concluding remarks on this debate over laïcité.
Well, this is the debate. This is the core of the controversy around Bill 21 is competing conceptions and competing visions of what is the pluralist society we want to be. And the question is our state, is our government, our institutions, are they to be neutral between religions or are they to be anti-religious? And we have certainly advocated for the former, for a state neutrality that welcomes and accommodates all religions and non-religions.
I wish we had more time, guys. Fascinating conversation. Thank you so much.
Thank you.
Thank you so much.
We've heard today about the Quebec law that prohibits government workers, from teachers to judges to police officers, from wearing certain religious symbols, be it a headscarf, a turban, a skull cap, or a cross. This law is a clear limit on religious freedom, a limit that it appears the Quebec government knew when it enacted could not pass charter scrutiny. That's why it invoked Canada's notwithstanding clause, Section 33, to get around the rights violation. And while the Quebec court upheld the law, it's extremely likely the decision will be appealed. But if Section 33 was part of the bargain that was struck when the charter was enacted, it should be available to governments to use. Was this one of those times when Section 33 was appropriate? Did the Quebec court make the right decision? Or is this violation of religious freedom something Quebecers can't stand for? You be the judge. I'm Christine Van Gyn, and remember, a freer Canada starts with you.